Welcome to seminar where seniors are being told about power of attorney, bill, and advanced care planning.
Everyone is back. So sorry. So first of all, I want to acknowledge this presentation is occurring on the traditional territories of the Coast Spanish people, including the Semiahmoo, Katsi, Tukwekam, Kwantlen, Hittite, and Sawaxi First Nations. Seniors First BC is over 200 First Nations across British Columbia, and we thank them for exploring these lands and waters since time immemorial. We engage in dedicated outreach to elders, and we're here to assist and serve all seniors in British Columbia. So Seniors for BC is a charity and a nonprofit organization. We have more than just legal programs. We provide information, legal advocacy, and support for older adults across BC with issues affecting their well-being. Our first and bigger program is the Seniors Abuse and Information Line, also referred to as SAIL. It's a helpline for seniors and those who care about them to speak about issues that affect their well-being, whether it's housing issues, health issues, navigating issues in residential care, or any type of access to home support and so forth. Then from the helpline, people can be referred to our other programs or external programs. When it comes to our internal programs, we have a victim services program to assist older adults who face serious issues of abuse, physical abuse, emotional abuse, and so on. We have a community engagement and outreach program, which Linda and I today, when I speak, are part of, where we present on topics of interest to seniors, whether it's advanced planning, housing, government benefits, elder abuse, and many other presentations. And we have legal programs. So that's the number of our Seniors Abuse and Information Line. It's on the internet as well. It's open from 8 a.m. to 8 p.m. every weekday, except on statutory holidays. So I'm just going to get to the core of this presentation, and I'm going to talk about representation agreements. I'll explain what these are, advance directives, powers of attorney, joint ownership, and wills. So sorry, I'm going quite fast because there's a lot of information, and I want to make sure that you get a good overview of the various advanced planning tools. If I go too fast, please raise your hand. First tool I want to discuss with you is our representation agreements. So it's a written legal document signed by the adult, appointing one or more people, referred to as the representatives, to make decisions on your behalf, on the older adult's behalf. The adults and the representatives must sign in front of witnesses, but it doesn't have to be at the same time. So people can come to an appointment, sign a document, and later on their representative can sign. Only the adult needs to sign in front of witnesses. It can be revoked as long as the adult is capable. So there are two main types of representation agreements. The most common one is what we call the Representation Agreement Section 9, because it's under Section 9 of the legislation. So it's to include all major and minor healthcare and personal care decisions. So it's not about finances, it's focusing on health and personal care. It can include day-to-day decisions, so what will the person eat, how they will dress, what type of care they might need. So if you need someone to talk to a care team about physiotherapy, what the care plan should be, particularly in a long-term care facility or in assisted living, or at a time where you are not able to make your own decisions or advocate on your own behalf because you're in hospital, then the representative is the person who will be able to talk to the care team, talk to the doctors, talk about who can be a visitor, and what the care plan should look like for you. Representative can refuse certain medical treatment, and it's often combined with an enduring power of attorney. And I will talk about what powers of attorney are later on. Just before I go back. So this is a typical document required before someone goes to some type of senior house. You usually want that document. The power of attorney will be helpful when it comes to financial decisions, but in terms of who decides where the person should go, that's the person with a representation agreement. And it could be the same person who holds a power of attorney and a representation agreement. Okay, so now there are representation agreements section 7, and those include both financial and healthcare decisions, but it's more limited in scope. It's used usually for people who have lost some capacity, they have diminished capacity, so they cannot give typical power of attorney, or sign full section 9 representation agreements. So that's what they can sign. It's a bit more complicated in that if the person appointed is not a spouse, there will need to be a manager. So it's a third person who will be there to oversee what the representative is doing. So that's for the routine management of financial affairs, legal affairs, and routine health and personal care decisions. It's not always accepted in or by long-term care facilities or assisted living facilities. So the gold standard is to have a Section 9 representation agreement and a power of attorney. But in any case, whenever you choose a representative, you must choose someone you trust because of the enormous power they can have over you. It means that you must have, or you should have, discussions about what your care entails and what it should look like if you lost your capacity, if you lost your mobility, if you had diminished mental health capacity, you didn't have the power to decide who should come to see you. That person can decide who will come and visit you, and therefore bar entry to other visitors. That person can decide what type of treatment you have, what food you eat, what your spiritual care may look like. And therefore, it is very important to have those discussions with that person and make sure that even if they don't feel the same way about any of those topics, that they will respect yours, that they will respect your wishes. And it's good to keep them updated about any medical issues they may have, treatment, so they know what care they need and who they should talk to if anything happens to you. When you don't have anyone you can rely on for support or name other options, but that's another common one that we can assist people to execute, when it's execute is to sign. It's a document with written instructions, setting out what type of treatment you want, and together different case scenarios. Should I get terminally ill, I would like to have so and so by my bedside. Should I get ill and go to the hospital, I do not want blood transfusions, or whatever is important to you. That could be in that document. It is better if you can to have a representative because healthcare changes. Your personal health can change, and a representative may be more up to date and think about all the various case scenarios that can happen to you, and it's good to have an advocate there for you. But if you don't have that, it's still good to put it in writing, to put your wishes and what matters to you when it comes to your health and personal care in writing. Now, when it comes to powers of attorney, I referred to those earlier. So, a power of attorney is a written legal document signed by you, the adults, and by the attorneys. So, attorneys are not necessarily lawyers. It's a confusing term. But under this act, the Power of Attorney Act, an attorney is someone who's appointed under a power of attorney to make legal and financial affairs on behalf of the adult who signed the power of attorney. Does that make sense so far? Okay. So in this case, like everybody must sign in front of witnesses, and if there is land involved, then a lawyer or notary should sign and be present to take the signature of the adult and the witnesses. It does not have to be at the same time, but if there's land involved, a lawyer or notary must witness the signature of each person who's going to sign this document. The document is effective as soon as the adult has signed and one of the attorneys named in the document has signed. There are some exceptions. But I'll go over this later on. So generally, that's how it's set up, and it can be revoked as long as the adult is capable. Once you lose your mental capacity, you can no longer revoke that document or cancel it. So these are used for financial decisions, business decisions, banking, and legal decisions. It doesn't work for maid. Some people ask me about this. Neither the representation agreement nor the power of attorney can be used to consent to maid on behalf of someone or refuse it. It does not apply to healthcare and personal care matters. Also, the minute a die, it stops to be effective. Many times I've talked to clients or people who seek legal services and ask, what document do you need? You want a will, a power of attorney, representation agreement? Like, I don't need a will, I already have a power of attorney. Well, it's great that you have a power of attorney, and we'll review that to make sure it's still good to go and it's still okay with what's in there. But the minute you pass away, that document ceases to be effective. So there are various types of powers of attorney. The most common are a springing power of attorney or an enduring power of attorney. So springing power of attorney is effective upon the occurrence of a specific event. It springs into action. It becomes effective when something happens. So the most common one would be, I would like this power of attorney to be effective once a doctor or two doctors have confirmed that I am no longer capable of managing my own affairs. And therefore, even if it's signed by you and the attorney or joint attorneys or alternate attorneys, it will be dormant until you are taken to a doctor or two, depending on how many you want to check and state that you're no longer capable of managing your affairs. And once they have issued a certificate of capability stating that you're no longer capable of managing your affairs, then the power of attorney becomes effective. An enduring power of attorney is effective as soon as you sign, you the adult, and the person you've named, the attorney or attorneys, have signed. Effective immediately. When that document is signed and pre-executed by everyone, both you and the attorney can make decisions about your legal affairs. You don't lose the right to make decisions about what's happening, where to make transfers, where to pay rent, where you should live. You both have the power to sign contracts, unless there are some limitations in that power of attorney. But the minute you become incapable, and there is a certificate of incapability that is issued, only the person named, the attorney, becomes able to sign those contracts and make financial and legal decisions on your behalf. Any questions so far? Sure. Yeah. Yeah.
senior first
Yes,
BC.
yes.
Okay, if any person,
Yeah.
like when you retire, we become old, he wants to go to live in BC BC apartment center, BC housing,
Yeah.
for seniors.
Yes.
Okay. After a few years, then he can go to the caregiver when he not able to, look after himself. So, how can you help us, like, if I want to go live in BC housing?
Yeah. You or the person you care for?
No, like myself, 2
You.
years,
Yeah.
after 2 years,
Yeah.
then I can do caregiving, like caregiving.
Like a senior house?
That's enough. That be. You know, like they said, one apartment, one single apartment, $40 or $50 for the single.
Right.
So you learn about any help for those people who want to live himself for like 2-3 years. Then when he become very old, then he can go to caregiver. Then he can choose. Is there any help for those?
We don't have the housing direct, no.
It's not about the money.
No, it's about the money, it's about housing.
Yeah, housing.
So if someone has question about how can I help my mother, my friend, whoever you're caring for, secure housing and it will sell, they will tell them who to contact, depending, so if it's BC housing, if it's independent housing, like it could be BC housing, it might be, yeah, well, there's BC housing for seniors, there's Brown housing, if there is a need to go to a care facility, usually that goes to home health, and they would add the person on the wait list, but we would look into ensuring that you have the proper documentation in place so that you can help you or that someone can help you find that housing if you lose capacity.
Very good understanding. But there is no help from this, your department. This is department.
From sale, not from the legal department. From sale, they could tell you who to call to get added to the wages, but no, we don't do that.
So senior first BC is only about the health center and health.
No.
Caregiver.
There's a right. So we offer, so we have the helpline. If someone say, where do I go to find housing? They would call sale.
Thank you.
If
Thank you for your advice.
yeah, details are okay. That can be sale. So going back to so far representation agreements, partisan attorney, yes? All the previous ones. So if you have a general power of attorney about all of your affairs, and the next day you go to the bank to sign a bank power of attorney, and you haven't struck down that first sentence that says, I revoke all prior powers of attorney, etc., then it just cancel the previous one. Just to know about this. Very briefly, when you pick an attorney, make sure you choose someone you trust. It doesn't have to be your oldest child if you have children. Just pick someone, it could be, but think about who's really good at record keeping, who's really good at following your wishes, who do you trust fully with your money, because recovering that money once it's gone is very difficult. Who will make good decisions about your behalf. And if someone else disagrees with what they do, will they be able to manage the situation, and to deal with all the others, if there are any in your family who say, no, it's not what should happen, like, is it something you can take on? But the first consideration is, can you trust them? And then will they understand and respect your values, wishes, and beliefs? And then you should know where you start with, what bank accounts you have. Okay, then there's joint ownership. Most of you, if you have any property and it's in a joint account, you know what it means. But a few things to think about. Once you have joint property, especially joint bank accounts, their debts are your debts and vice versa. So if you have a joint account holder who's a child and something happens, they get scammed, there's a fraud, something happens with their partner, you could be liable for those debts. Whereas if they have a power of attorney, your bank account does not become their bank account. So it's because when you have a power of attorney, they only have the authority to use that money for your benefit, not for their benefits. So things are kept separate. When you have a joint bank account, it's likely as much theirs to use as it is yours to use. There are some exceptions. So whenever you set a joint bank account, talk to your bank and ask them, what will be the implications? What will happen when I die? Sometimes people have a joint bank account with one child, but they have more than one child. They have several children. And the question is, when they die, will everything on that bank account go to the joint account holder? And therefore will you disinherit the other children? There are ways to set this up in certain financial institutions where there's no right of survivorship, and that's what I just explained to you. So just think a lot about what can happen with those joint bank accounts. The debts can become shared, and do you want to disinherit anyone who's not a joint bank account holder? So that's a conversation we would have during a legal appointment if you had a joint bank account, or if you were considering having a joint bank account instead of a power of attorney. Alright, so that's what I just explained. Now the wills. So wills, documents that contain instructions on what you want to happen with everything you own and with your body. So it includes the appointment of an executor and an alternate executor. If something happens to that executor, it's effective only after death. And some assets cannot be distributed in a will. So if you have a life insurance, it goes straight to the beneficiaries. If you have a joint bank account, it might go straight to the beneficiary and not go through the will. And there are other types of joint properties and investments accounts where it just goes to the beneficiary. So for a will, consider who can be a reliable executor. Who do you want to leave your assets to? As lawyers, whenever we take instructions, we have to make sure that everything that you own is disposed of in the will. Even if there's just $500 left in that will, it must be clear where it goes. What should happen if the people you leave your assets to or your executor dies first, or they become incapable, or they leave the country? So we often ask you, well, we ask you all the time, every single time we'll ask, if they can do it, who could be an alternate executor? And if you don't have one, that's okay. There are work around that. There are ways to work around that. Sometimes you can appoint a public guardian and trustee to be your executor. Again, this is a high-level overview of things you have to think about before you make a will, but you should talk to a lawyer about this. And we have, as Sarah Lee mentioned, we have free legal clinics here for people who cannot afford a lawyer and who meet our eligibility. So think of the executor, the beneficiaries, backup executors and beneficiaries. If you have any minors in your will, who should be the trustee? Who will manage their affairs if they are still minor beneficiaries at the time you pass away? And we'll need their full legal names and addresses. And there's no exception. So please make sure you have their full legal names. So when choosing an executor, as mentioned, for the power of attorney, for the attorney you appoint, it's the same type of considerations. You should think about who can handle all of those duties. There's a lot that's going to happen, and they need to keep a cool head, right? They will deal with the last taxes, with the probate process, going to the court registry, dealing with any existing debts, credit card debts, and so forth, dealing with your furniture and your personal possessions. They will deal with funeral arrangements. Is that something else we'll discuss during that will appointment, or that, you know, if you talk to a legal professional, they will discuss what you want for your funeral. You know, have you thought about it? And sometimes people say, oh, the executor can deal with this. My kids know what to do. And it's great if whoever is going to be an executor, whether it's a friend or a kid or the public guardian trustee, knows what to do. But there are so many disputes over this, so many disputes over whether there should be a church ceremony, whether there should be no ceremony or another type of ceremony. What happens to the ashes? Or, you know, people fight over this, and it is very traumatic for everyone involved. So instead of just keeping it vague, if you can set those wishes in writing, it is much easier for that person, the executor, to execute your wishes and follow them, and also fight any dispute. You know, say, no, she put it right in there, or keep it right in there in that document, you want it. No ceremony, or whatever matters to you, you know, or ceremony, and there should be some music, whatever matters to you, it should be in there, because it makes their life so much easier and prevents fights. With that, keep in mind the costs of those funerals. Sometimes we have conversations with people who are religious and want to be buried. Sometimes a religious congregation can cover those expenses, but sometimes it's not possible. So it's something to think about, whether it's feasible, because those are wishes. The executor has a duty to do their best to honor the wishes of the deceased, but it has to be reasonable and feasible. And then think about where you're going to pass, where is the executor, how far are they, can they come to your unit and do what is needed. So it's difficult if they are in a different province, but maybe they can travel easily. When someone passes without a will, who inherits? Family members, following the order set by law, so the spouse, if there is one, with the children, etc. So many of our clients do not want all their children to inherit equally. So if there is a child you do not want to give money or something to, it's definitely important to have a will, because there could be a dispute around that. As a last resort is the government of BC. If there is no executor, then an administrator of the estate should be appointed. It's a longer process, because anyone who can be an administrator, has to make an application to court, has to notify all the other people who could be appointed administrators if they agree with the appointment or not, and if not, it can be fought in court. So again, having a will can make even just that process a lot easier. It sets like who has the power to make decisions, as a spouse, a child, and it can be complicated for those who do not want to rely on family, or who do not have family to rely on to help them with their health care. And if all fails, if there's nothing in place, then there might be a need to go to court for a committeeship application. We're doing one for someone right now. A committee application is very expensive.
Tonight we're having our holiday concert at City Hall. It's our annual holiday concert, and I know that the registration is already half full. So if you want to sign up for that, I would encourage you to do that as soon as possible. And thank you so much for being here today and being part of this event. We really hope you have a great evening. Thank you.